and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Felipe Jiménez, Assistant Professor of Law and Philosophy at the University of Southern California Gould School of Law. We will discuss his draft article, The Case for Formalism in Contract Law Adjudication. So welcome to the show, Felipe.
Thank you very much for having me.
The pleasure is all mine. I really appreciate you reaching out and inquiring about being on the show and sending me your paper to read because it was fantastic and I learned a lot. And in particular, I learned some things that I think I might have to incorporate into my own work. So thanks a ton.
Thank you so much for reading the paper and for having me.
Okay, so I thought that for listeners who might not be sort of steeped in legal theory, we could start by sort of having you explain some of the terminology or concepts that you use in the paper to talk about how we should think about contract law. So as you note in your paper, formalism kind of has a bad name among legal scholars and has for a while. And so there's this truism that we're all realists now, to sort of riff off Nixon a little bit, right? So what's the difference between legal formalism and legal realism, just in a nutshell?
Sure. I would say that formalism is the idea that judges should decide cases and typically decide cases by applying pre-existing legal materials. And that might be statutes or it might be precedents. And realism is basically historically a reaction to 19th century formalism. And it's a reaction that basically claims first that descriptively that's not correct and that judges basically figure out what outcome they want to get based on their policy preferences. And then they provide some sort of account for why that outcome might be justified on the basis of law, but that's not really what's driving the outcome. And normatively, I think legal realists were committed to a view of law reform that was that saw the task of the judge as not just applying law, but also advancing normative outcomes that they believed were desirable. And so I would say the opposition is both at the normative and at the descriptive level. And you can see this opposition playing out, first historically between the 19th century formalists like Langdell and then the realist backlash against that. But also you can see it nowadays, for instance, in contract interpretation, there's a long dispute between people who think that judges should try to narrow their attention to the four corners of contracts and so on and so forth, whereas other people who think that actually judges should look at context and extrinsic evidence in order to try to make sure they get the right outcome.
Okay, so just to clarify or reiterate then, the sort of realist objection to formalism then is twofold in the sense that realists say that not only is the sort of descriptive account offered by legal formalists not how judges actually go about deciding cases, but also the sort of normative goals of formalism are not the right normative goals or not the goals we should have. And we should be thinking more about sort of outcomes and the kind of policy outcomes in particular cases rather than trying to apply neutral principles. Is that more or less the sort of distinction there?
I think that's right. And I think that that realists saw the commitments of formalism regarding the institutional position of judges as basically an obstacle to social change. And so, and you know, in all fairness, that was actually true to some extent. So if you look at Lochner, that seems to be a clear example of that problem that the realists were identifying.
Yeah, I mean, Lochner is kind of the paradigm example of legal formalism run amok, at least in the legal realist account, it seems.
Right.
Yeah. Okay. Well, so you also distinguish between instrumentalist and non-instrumentalist theories of law. And I wonder if you could talk about what that distinction means, especially or in particular in relation to contract law and the goals of contract law.
Right. So I would say that instrumentalism is just the view that law is a means to an end. And in a sense, it's almost part of the air we breathe in the US. So not just because of legal realists, but after that, if you think about, the legal process school, if you think about law and economics, even if you think about critical approaches, critical legal studies and critical race theory, I think all of them have this view of law basically being an instrument of goals, and that those goals might be connected to economic efficiency, as in law and economics, or they might be connected to sort of the pure politics, like in the more critical approaches. And in private law, instrumentalism has basically been the main approach used by law and economics scholars. And therefore, non-instrumentalism, in a sense, is a reaction to the dominance that law and economics once had in contract theory. So, in the 1970s and 1980s, I think, particularly in the law of torts, sort of deterrence accounts and utilitarian accounts of the law were pretty much dominant. And so in the late 80s and early 90s, there's this professor at the University of Toronto, who's Ernest Weinrib, and he starts developing a sort of non-instrumentalist theory of private law that responds to law and economics, and basically responds to everyone who thinks that law is a means to an end, and says actually law is sort of a self-justificatory enterprise. It justifies itself, and in order to make moral sense of the law, you don't need to reach out to other normative considerations beyond those used by legal doctrine and by judges. And in that opposition, I definitely see myself as part of the instrumentalist camp. That is, I don't think there's much sense in denying that the reason why law matters and why law has value is because it helps us achieve, morally important ends. Now, the difference that I have with most law and economics scholars is twofold. So the first difference is that my understanding of the values that underlie legal institutions and the law of contracts in particular is, I think, more pluralistic. So I'm not just committed to the view of efficiency as the goal of legal institutions. I think we care about other things beyond efficiency. And in the paper, I discuss, for instance, autonomy as one important goal served by the law of contracts. And the second difference between my approach and sort of the classical law and economics approach is that I make a distinction that I think they fail to make between the justification of legal institutions and the justification of the actions that agents within those institutions take. So I basically separate questions about what justifies the law of contracts or what makes the law of contracts valuable from questions about how judges should decide disputes. Whereas if you look at, for instance, Richard Posner, it's very clear that he thinks that whatever you say about contract law's foundations will also have an important bearing on, not actually just an important bearing, will actually determine how judges should decide cases.
Mm-hmm. Well, so I usually associate formalism with non-instrumentalism in the sense that there's kind of like people like Weinrib, but many other scholars who you mentioned in the paper as well, seem to look at kind of formal legal doctrine and including formal contract law doctrine and imbue it with a certain kind of intrinsic normative weight. But you offer a instrumentalist account of formalism, which I found a really kind of interesting and provocative move. I mean, how do you avoid non-instrumentalism in sort of advocating a formalist approach? I mean, you touched on it a little bit a moment ago, but maybe you could expand on sort of how you can avoid that non-instrumentalist tendency that's so common among formalists?
Sure. So I think in most of recent scholarship in the US, what you typically see, so if you think, for instance, about Ronald Dworkin, right, who is in a sense the quintessential jurisprudential version of American legal culture, he thinks that judges need an underlying theory of law to decide cases, and therefore that there's no important distinction between what judges do and sort of the ultimate grounds or the ultimate justification of legal institutions. And I think that just captures a very widespread structural assumption about legal institutions that a lot of people seem to have, which is that basically whatever is true about the law's moral foundations, or whatever theory explains or justifies the foundations of legal practice or legal institutions, also plays a crucial role in the adjudication of actual disputes. So that, for instance, if you think that the law is about efficiency, you should also tell judges that they should decide in a way that maximizes social welfare. Or if you think that, for instance, punishment is an institution justified because we want to deter crime, the judges should decide on the basis of what will deter crime overall. And what I respond to that assumption, sort of my response to that assumption, is that actually it doesn't make sense to think that way about legal institutions, because when you look at legal institutions, you can basically separate questions about why we have those legal institutions and sort of evaluative questions about the value and the moral worth of those legal institutions, and questions about how specific institutional agents should behave within those institutions. So in a sense, a distinction between justifying legal regimes and applying the rules that are part of that regime. And this is a distinction that has a long history in legal and political philosophy. So it's a distinction that John Rawls articulates in this paper, Two Concepts of Rules, which was published in the 1950s, and which has had a really significant impact on the way I think about law and social practices generally. But I think it's also implicit, for instance, in H.L.A. Hart's distinction between internal and external perspectives to legal institutions. So what I think is wrong, both in Weinreib's view and in the law and economics view, is that they fail to make this distinction. So law and economics thinks because efficiency justifies private law judges should try to achieve efficient outcomes in their decisions. And Weinreib, in a sense, makes just the mirror image mistake, which is thinking because judges can only consider a certain limited domain of reasons and considerations, that's the end of the story for the justification of private law. And that's why he ends up with this claim that basically private law justifies itself. It doesn't need to refer to sort of extrinsic ends and values.
I mean, if I may, it kind of struck me that you were making both like a descriptive and a normative objection to these kinds of more theoretically rich or kind of more theoretically driven accounts of how legal decision making happens, in the sense that, like, it seems like there's this presumption that legal theory is necessary to making legal decisions. And it seems like you kind of question how deep a legal theory you really need to adjudicate cases. And also there's this assumption that that's what judges are actually doing. And it seems to me that actually it's like someone like Posner is almost like the exception that proves the rule. And most judges don't think that that's what they're doing, right? They think that they're doing more or less doing formalism.
Yeah, so I think that's perfectly right. So there's this very kind of typical phrase, you need a theory to defeat a theory, right? And so the underlying idea seems to be that if you don't like how a certain judge is deciding certain types of disputes, you need to come up with a whole theoretical framework to oppose that perspective. And you see this, I think, playing out in a bunch of different fields. So you see it in private law, in the discussion between sort of early law and economics scholars like Posner, but also like Louis Kaplow and Steve Chevelle on the one hand, and on the other hand, people like Peter Benson or Ernest Weinrib. But I think most lawyers and most judges don't think that way. That is, they don't think you need a really articulated interpretive or justificatory theory about legal institutions in order to make good decisions within them. And in fact, if you think about sort of how we have designed law schools and how we have set up courts, that seems to vindicate the idea that actually what drives legal education and also legal reasoning as an institutional matter is not having great articulated theories about ultimate questions of justice or about how we should organize society, but rather that it's a much more narrow and technical set of questions and expertise that we're going after. And in a sense, I'm trying to provide a philosophically ambitious argument for that sort of philosophically unambitious approach to legal adjudication and to legal institutions generally.
So maybe we could talk a little bit about how that would work in practice and maybe even like specifically in a contract law context. So when it comes to like, for example, like hard cases, right? We know that there's like multiple different kinds of hard cases and that, judges do in fact decide them, many of them formalistically, some of them in a more kind of legal realist inflected fashion. Sort of how can and should legal formalism on the ground deal with hard cases? And why do you think a formalist approach is preferable to a realist approach, in the actual adjudication process?
Right. So I think legal formalism, in the way I describe it in the paper, has the tools to deal with hard cases. And I discuss in the paper two types of hard cases. So some hard cases might be hard because the legal materials just don't give you an answer, or they're ambiguous in the answer they give you. So they're indeterminate in a sense. Or hard cases might be hard because the legal materials seem to give you an answer and the answer just seems on its face inadequate. And then the question is how you deal with those two situations. And I think sort of the strawman version that we're used to about formalism seems to suggest that in those cases, formalism says, the judge just needs to apply the law. If the outcome is terrible, well, so be it. And it doesn't matter. But I think if you actually look at most of the sort of doctrinal tradition in private law, that there are several tools that judges use to deal with these situations. And this is just a really long tradition. So if you go to Savigny, who's a German jurist, more than 200 years ago, he already had a very sophisticated account of how judges could deal with situations where rules gave you inappropriate outcomes that just didn't involve sort of, embracing full-blown discretion or just policy making. So I think there's a long tradition for that. And I think the most familiar way in which that operates is through legal principles and legal concepts. So basically these kind of more open-ended legal standards that allow you, on the one hand, to expand the law and to reach adequate outcomes when on its face the law doesn't give you the right outcome, but also to do so in a way that's constrained, that's that doesn't break with the previous tradition, and then that in a sense seems to flow from that tradition rather than break from it. And I think the best example of this is the jurisprudence of Cardoso, though I know some people will disagree with that characterization of his approach. And turning to the second part, which is why it's good to have this sort of approach, I think there are reasons that are peculiar to contract law, that are connected to the values that contract law plausibly serves. So if you think about efficiency and autonomy, I think both of those sets of concerns should lead you to value predictability, uncertainty, and doctrinal stability. But I also think there are values beyond the law of contracts, so typical kind of rule of law values that that would advise for a formalist approach. And the last thing I will say is, I also think that the very way in which judicial institutions are set up suggests that we actually don't want them to try to take into account all of the relevant information about the outcomes of their decisions, about the effects of their decisions, and rather that we want them to narrowly focus their attention in just a few important and central aspects, rather than just engage in honestly what is in the end a bit of intuitive guessing about what the outcomes, the practical outcomes of their decisions will be. Because typically, given the way in which they're set up, judges just don't have access to what the effects of their decisions will be.
So, I mean, it struck me reading the paper that one oddity, or kind of about a lot of other instrumentalist approaches, they seem very focused on individual decisions and individual outcomes. And it seems to me that in a way, what you're suggesting is that when we think about how we want institutional actors to do legal decision-making, to do adjudication, we should be taking a more holistic view and not necessarily always asking about the outcome of particular cases, but asking about the kind of functioning of the system as a whole, and whether that produces the kinds of outcomes that we want. Is that a fair take on what you're saying?
Yeah, I think that's right. So I think when you just think about one specific case and one specific judge, it's very easy to feel the pull of a very open-ended, contextual, and unconstrained approach to decision making. Because basically the idea is that, at least up to a certain point, more information and consideration of more sort of data points will help you make more fine-grained and sort of context-sensitive decisions, right? And therefore, in every one given instance, it seems that there's not much value in following sort of strict rules and applying them. But the instrumental value of rules and the instrumental value of legal formality generally is not captured in the specific instance, but it's rather captured from a wholesale perspective. So the crucial question in theories of adjudication is not how one judge would decide a specific dispute, but rather how we want judges in general and in a coordinated way to decide disputes. So if you think that, if all you're thinking about is how would Cardoso or Posner or Easterbrook decide a contracts case, it's very easy to think, well, actually, we should consider all the relevant information and let the judge decide what's best, all things considered. Because after all, these are great judges, and there's a reason why they're so famous, and their opinions have been considered as important sources of learning and teaching. But if you think about sort of the median judge is probably not like Posner, Traynor, and Easterbrook. And if you think about the long-term effects of inviting judges to act as if they were, Easterbrook or Cardoso or Posner, or as Dworkin's Hercules, well, the outcome will probably be not as good as it looks like when you just think about one specific dispute.
Yeah, I mean, it's interesting. There's a kind of humility to the approach you're suggesting. I mean, it's like you're asking institutional actors, but legal theorists as well, to be more humble, both about their role and also in some ways like what they have to contribute to the adjudicative process.
Yeah, so that's definitely true. I think there's a sense of a lot of epistemic humility that is connected to the I would say to this paper, but generally to my scholarship and sort of to my research agenda. So I very much agree with this sort of Hayekian point that no one really knows enough about how social institutions and society generally work. So we should be really cautious about sort of inviting institutional actors to engage in big changes and to sort of leave aside the institutional constraints that they face. I think there's a good reason for those institutional constraints. But also because of that, the argument I make in the paper is tentative. So I'm open to considering objections, and I say in the paper that basically empirical evidence and sort of actual facts have the ultimate word in what the right approach to contract law adjudication is, or to adjudication in any other area for that matter is. But what I'm trying to give here is a set of general arguments as to why, the usual bad name ascribed to formalism is not actually justified, and there's value in thinking about how a more constrained approach to adjudication would work in the resolution of contractual disputes.
So you use the term value pluralism quite a few times in the paper, and I think you've touched on this issue a little bit already, but I wonder if you could talk a little bit about sort of what you mean specifically by value pluralism and how you think a more kind of formalist forward approach to the actual process of adjudication would be more consistent with plural values than alternative approaches suggested both by other formalists but also by realists.
Right. So this is also one big difference that my approach has with most instrumentalist writers. So most instrumentalists, and particularly legal economists, are typically thinking of just one value, economic efficiency, or something, like wealth maximization or something like that. Whereas I have what I label as a more pluralistic approach. So first, value pluralism is this idea that there's not just one thing we care about. We care about very different things, and we care about them in different ways. And so in the case of contract law, for instance, I think that we not only care about contracts because they help us structure markets and because they allow parties to maximize their joint gains, but also because they are an important tool for people to develop their life projects. They give them authority over their rights and obligations, and that has moral value. And also because contracts, in a sense, establish a limited but important form of equality in social relationships. And because I believe that that's true about the foundations of contract law, I think telling judges to engage in open-ended decision-making to try to find a right balance between those values is a recipe for unpredictability and disaster, because it's not easy to know how you trade off these different values and how to decide in cases of conflict. And so I think that formalism has a lot of value as a decision procedure that basically ignores those ultimate questions about moral value and tells judges to try to decide on the basis of more narrow and less, less foundational reasons. And the second thing I would say about value pluralism is that even if you don't agree with me that the foundations of contract law are plural, and you think that there's only one value underlying the law of contract, so it might be, promissory obligation, or it might be efficiency, or it might just be autonomy, and so on. Even if you thought that, as a matter of fact, people don't agree about what the foundations of contract law are. And so if you read, what has been written in contract theory in the past 10 or 15 years, you will note that for every scholar, there's one theory. So basically, no one agrees about the foundations of contract law. And inviting judges to try to make decisions on the basis of those foundations would just replicate that disagreement. So in a sense, formalism is also a good way to deal with that, the fact of pluralism about contract law's foundations.
So I wonder if you could talk a little bit about legal change as well. Like how and when can and should judges engage in changing the doctrines that formalism tells them to apply, and to what extent or how should we apportion the authority to make those changes as between the judiciary and the legislature?
So in my view, it's inevitable that given how legal materials are structured and the limits in the ability of those legal materials to give you a determinate outcome for any case, that judges will sometimes have to develop the law and go beyond what those legal materials give them in terms of ways of addressing contractual disputes. But then the question is how you develop the law, how legal change is done by judges. And I think we shouldn't abandon the sort of underlying commitments for formalism in easier cases. And in that case, the question is, what mechanisms does legal doctrine give you to develop the law? And I think legal principles can play a crucial role in that. The other thing that I would say is that my theory is sort of heavily dependent on the time and place where you're at. So I say at some point that basically this is a theory for the current law of contracts in contemporary Western jurisdictions. And the reason for that is that in earlier stages of development, where you just didn't have enough legal materials and enough law, I would be much more open to have a more open-ended decision procedure where judges can basically innovate and generate new doctrines and new rules. But I think that given the stage of development of the common law where we're at, the gains from a more open-ended procedure just are not sufficient to warrant giving judges that authority. And so I think it makes more sense to, on the one hand, allow them to develop the law and to expand the reach of legal materials, but on the other hand, to tell them to do that in a way that's constrained. And so I think the best example of that approach is Cardoso. So Cardoso innovated in several aspects of contract doctrine, but he also did that in a way that connected those innovations to pre-existing legal materials. And I think that's the right way to go about it.
So in closing, would you characterize the argument you're making in this paper more as this is how we should think about legal adjudication and the sort of framework in which adjudication ought to occur, because it will have these kinds of instrumental outcomes, or kind of a descriptive account of this is what's actually happening and that's fine, and objections to that are mistaken because it does in fact produce better outcomes than the alternatives?
Sure. So I would say it's a normative argument. So I'm saying why there are good reasons for this approach to contract law adjudication. And as you know, the reasons are connected to consequences and to the impact of this decision procedure as compared to other approaches to contract law adjudication. But at the same time, I think, in a sense, I'm also vindicating a kind of the traditional approach to legal adjudication. And I think, it's okay and it's valuable to have a critical approach towards judicial discourse. And it's valuable to critically evaluate the law and to say when judges go wrong, but also that we should be careful of not, also losing all the benefits of this really long tradition that I think, in fact, exists in most legal systems, at least in the civil law and the common law. I think in both cases, there's a tradition of centuries of thinking carefully through legal materials and legal concepts, and I think we shouldn't lose that. While at the same time, we should be completely aware, as the legal realists taught us, that law is an instrument of politics and that we should always have our critical eyes open to morally evaluate and try to change law when it's problematic.
Yeah, I mean, there's a way in which the project is almost kind of like meta-realist to me, in the sense that you're kind of advocating to step away from the individual decisions and outcomes and think about the kind of big picture institutional questions.
Yeah, I think that's right. And in a sense, I think, I overstate the differences between my approach and the realists. So I think some realists would be actually sympathetic to this approach. And most realists, I think at least the best ones, so if you think about Pound, for instance, I think they were actually really careful and thoughtful about legal doctrine. So I think, just as formalism has been deformed by this sort of strawman version, there's also a deformed version of realism. So, perhaps that's the next paper.
Awesome. Well, Felipe, thank you so much. It's been great having you on the show. I think this paper is fantastic, and I look forward to seeing the final version in print probably sometime next year or something, I imagine.
Yeah, thank you so much for having me. It's been really a pleasure, and, just keep the show going.
Hiya, fellas. This is Sal, the service station man's pal. We've got some news for you. News we think you're going to like hearing.
During the week of May 16th, the second mailing of the Service Station Selling Program will reach your market. It's a bright 16-page, two-color catalog that shows off the complete line of B.F. Goodrich TBA merchandise, along with your line of petroleum products. On the cover will be featured the handsome barbecue grill that you've been hearing so much about.
I find it irresistible.
And we know that the grill is going to bring a lot of new faces into your station. Display it big.
A grill's best friend is its display.
Put plenty of grills out where the customers can see them. Spotlight them at their shining best with the display materials furnished. Make sure that your salespeople know what an important part the grill is designed to play in your whole summer selling program. Talk it up. Pass the news about it along to your friends and your customers.
We'll have the whole town talking.
But don't let your selling die when they've bought the grill. They've got the grill now. They must be planning to use it at the beach, on picnics, or during vacation time. For their safety, their comfort, and their motoring pleasure, they should make sure that their car is in tip-top shape.
I always like to keep things in good shape, don't you?
Bring them in with the grill. Then use its sale as a springboard to sell tires and other TBA items.
I'll be seeing you on the other side of this record.